session. The Honorable Harvey J. Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, this honorable court, and the state of
Please be seated. Good morning. This is actually the second oral argument we've had today. Of course, you were not part of the first one because the first one was by Zoom. But welcome to the 5th DCA, the reconfigured 5th DCA. As I believe I know both of you on both sides. My name is Harvey J. I'm presiding today. I had the privilege of presiding Tuesday for the first time on the reconfigured 5th DCA. Again, I have the privilege of being here with two very fine judges, Judge Soud and Judge Boatwright, who you probably both know as being fine judges on the trial bench, and I am certain they will be very fine colleagues here on the reconfigured 5th DCA. If there is nothing further for the court, I do need to tell you one other thing. We are planning to take a very short break in between these two oral arguments this morning. So after this oral argument, we'll take about 5 minutes before we come back for the second live OA of the morning. But Ms. Cohen, are you prepared to go forward? I am. All right. And how much time would you like for a rebuttal?
5 minutes.
We have that in place. Well, thank you, Ms. Cohen, when you're ready.
May it please the court. This trial began with a jury selection wherein the state asked the potential jurors about their trip in that morning. And she asked what they thought of the traffic, and they responded that it was horrible. And if that had been leading to something else, that would have not in and of itself been so much of an issue. But we proceeded from there to, did someone cut you off? How was your experience? Have you ever encountered an aggressive driver? How did that make you feel? What are some reasons that you have to pay attention while you're driving? And the first response to that was so you do not cause an accident.
So your argument, Ms. Cohen, is trial counsel for your client was ineffective for not objecting to those questions?
Yes, sir. And the problem is because each one compounded on the other. So we start with the aggressive driver, and how did that make you feel? There were no follow-up questions from either attorney as to how that would impact their ability to judge a DUI case and what impact that would have and whether they could make a fair and impartial decision.
Well, and I have two questions about that. And I know you know this, Ms. Cohen. The edicts from the U.S. Supreme Court tell us that we are to be deferential to trial strategy, and you appreciate that, correct?
Yes, sir.
Is it not sound trial strategy to avoid objecting in front of potential jurors?
If it's over the top, I guess, and if it's a minor thing, then yes, there might be some strategy to do that. But there comes a point where there is absolutely no strategy, and allowing a prosecutor to continue to go along the vein of the dangerousness of what occurred in this case, as opposed to the actual issues on a DUI. Were you driving? Were you impaired by, in this case, alcohol to the extent your normal faculties were impaired? The jury was not being called upon to decide whether or not there was dangerous driving in this case. The jury was not being called upon to decide whether DUI should be illegal. The jury was not being called upon to decide whether it's safe to drink and drive. The jury wasn't being called upon to decide any of those things. So the questions posed to the jury got all the way to, wouldn't you agree that this is a danger? If we allow this behavior to continue, that this is a danger to people and pedestrians. And by the way, Miss Third Grade teacher, don't you have children in a crosswalk? And so it just progressed from one point on. So maybe you don't object the first time, the second time. The third time you object and you ask to approach.
What would have been
bench.
the objection? What should he objected to? What was
The
the legal
objection would
objection?
be that the questions were not to get to the issue of whether or not these jurors were fair and impartial, but to inflame the jury, to test your case in front of the jury, to give them hypotheticals about, because obviously, as we found out later on, that was the issue in this case, was a witness who asserted this was an aggressive driver. And so what it did was it took the focus off of what the actual elements of the offense were. And the bigger issue is...
So you're saying the state's not allowed to ask hypothetical questions during jury selection?
Not regarding the specific facts of their case. They can, and obviously any kind of question that is geared towards determining somebody's, whether they're impartial or not. But these questions nobody ever asked these people what that meant to them, how it affected their ability to be a juror.
But you said the facts of this case, as I read the transcript, there was no reference to this case during voir dire. It was just general questions, correct?
General about aggressive driving. Again, that's not an element of DUI. And if there had been, have you been exposed to aggressive driving, things like that, or does that concern you? How would that affect your ability? And the defense attorney didn't come back and ask that question either. So there was no follow-up that might have made it different if there had been some follow-up. But the problem is there was no follow-up as to how that informed whether or not this juror was going to be fair and impartial. It only laid the groundwork for, oh my gosh, this is dangerous, what happened here was dangerous, this is why we have to have these laws, because people can get killed, children can be hit in crosswalks, and that was what the focus was of the state from the very beginning. The state even talked about field sobriety exercises and tells the jury that this is a good way to determine normal faculties. A police officer shouldn't just let someone go, should they? So...
How do we know it made a difference?
Because even if this court were to find that this wasn't enough to compromise the jury, which I would suggest it probably, that it would be, because by the time she finished, the whole focus was, this is dangerous and you gotta do something about it. But once you put that together, and I understand, if this was correct questioning of the juror, then obviously it doesn't add to a cumulative error. But because it was not, even if this court were to say, well, that in and of itself is not enough. What happened after this? In opening, the very first statement was
Is that something we could find, this in and of itself was not enough?
My position and my belief under the law is no, you can't. But obviously the court could differ with that belief. And so if the court were to disagree with me about that, wouldn't be the first time, then even if you took that apart, the very first thing in opening statement is the statement that there's a truck in front of us and somebody's going to kill somebody. Again, not an element of the offense, but again, carrying through. On the 2 pages of transcript where the questioning...
Wasn't that her testimony, though?
It was the testimony, but it, number one, puts the focus on... Well, let me back up. Obviously, if there had been some sort of pretrial motions, which the attorney didn't believe he needed to do, about some of that language, because while some of it is certainly relevant and the actual driving pattern may be relevant, then but you also need to get into whether the prejudice may outweigh the relevancy of the woman's conclusion. But by focusing...
So you agree that would have been maybe, you're talking prejudice, but it's relevant, her testimony as to why the officer started the investigation in the first place,
Why the officer
correct?
started it, yes, sir. But into that particular phase, but again, it dovetails into the focus from the very beginning of this is dangerous. Then 12 times, no, 9 times, I take that back, 9 times over 2 pages of testimony, which also gets into the opinion of the prosecutor, which she gave them during jury selection about field sobriety exercises, and we all agree that DUI is dangerous, or that being impaired is dangerous. She then goes into when she's questioning the witness. When did you first see this reckless driver? What did you do about this reckless driver? 9 times uses the phrase reckless driver. So now we have jury selection where the whole focus is on reckless driving, danger to the community, hitting children in school crosswalks. Then we get to the very first statement to the jury in opening about somebody's going to die. Then we get to this being a reckless driver in the opinion of the state, 9 times over 2 pages of transcript. Then
What about the testimony of the lawyers? I remembered, I believe, dealing with this, that if you object to something like that, you give it undue emphasis with the jury. Is that not a reasonable evaluation point, that objecting to things sometimes bring those things to the attention of the jury?
Certainly, if it was said 1 time, yes. But by the time you said it 9 times in the period of, I don't know, 5 minutes, or maybe 10 at the most, then I think that has already focused the jury on that term that you are referring to, especially once you have already told them that this person almost killed somebody, and you've told them in jury selection about the dangers and that killing children in the crosswalks. Then you get to the video, where we have a redacted video, and there's no objection to the video. So we're watching the video, and in the video, the officer's telling him about another witness and what that other witness had to say, who's not testifying, and it's clearly hearsay. And that's in the redacted video. And then at the end of the redacted video is the statement of the officer, first of all, first making contact with the witness, saying, I need to talk to you, and then saying, carrying along the same theme, I just investigated a crash here 3 weeks ago with the same, and the same circumstances. Again, that is not relevant to this case. That is not relevant to guilt or innocence. That just carries on the same focus from the very beginning. And I'm not standing here saying that anybody thinks that driving under the influence is a good thing, and our personal opinions as to whether there should be a law or shouldn't be a law and whether it's dangerous is certainly something we're entitled to and something that's important, and I think we all agree. But that wasn't the question in this trial. It was, was this person impaired by alcohol?
Let me ask you this, Ms. Cohen. Was there evidence in this record? I appreciate the argument. You've done a nice job laying it out in your briefs and today. But was there evidence in this record where a jury could find what they found as to your client?
Well, it depends, because if the question before the court is, if, first of all, there had been a motion to suppress based on the reasonable suspicion and everything got suppressed about the original, everything past the original stop, then obviously, no, they could not. But even if you take out the pretrial motions, if you take away all these statements during jury selection, if you take away the statement during opening statement, if you take away the repeated references to reckless driving, if you take away the fact that the defense attorney is the one that elicited some of the most damaging evidence from the arrest officer, he knew what that officer would say, and he gets up and the first question is, oh, you know, all you've said is odor of alcohol. Tell us more. What are some of the other indicators of impairment that you saw? So if you take that out, the other indicators of impairment, which were then argued by the state, if you take out the additional evidence of rudeness and intimidation by the breath test operator that the attorney elicited, if you take away the repeated, I think it was 10 times during closing that the prosecutor said he is guilty. He was so impaired that night. He was impaired by alcohol. He was guilty of DUI. The very last thing the prosecutor said was that the witness said she thought somebody was going to die. So if you take that away, you take away all the opinion, you take away the jury instruction errors, you take away the hearsay in the video, you take away the evidence that was elicited by the attorney. If you go back and you look at whether or not they had brought in medical evidence about his medical conditions that went into the decision to refuse field sobriety exercises, which became an issue. And I understand a defendant can testify to that, but I would suggest that it is not sound strategy to say that a jury is going to look at a defendant who says, yes, I have these medical conditions, in the same way in which they're going to look at an expert. And the explanation for the attorney was, well, he never gave me his medical records. There was no evidence that he asked for them. And that's the problem with the strategic aspect of this. There was no testimony that he actually investigated anything, and even when he talked about the strategy, he was not prepared. He's like, I don't really remember. I didn't look at my file. I didn't bring my file. I think that's as telling as anything else. And so even when he tried to use the buzzword strategy, it was a situation of, I don't remember, but I wouldn't have done this. I don't remember the state asking the jury anything inappropriate. I don't remember any inappropriate answers. That's not talking about a strategy. in the, and I know the court's familiar with McKendrick out of the First District Court of Appeal, one of the things the attorney there, when the court
So
overturned,
back to
was
my question,
they
Ms.
explained
Cohen,
everything.
and I know you've given a long answer, but you're saying there was insufficient evidence here for the jury to find what they found?
I think that it undermines the confidence in the verdict, and I think that it could,
And I appreciate
there's a
that.
likelihood that it did affect it, because if you take out all of that, what's left? And so there is, even the officer, before the defense attorney asked him, the arresting officer said it was the driving pattern and I smelled alcohol. That was it.
Well,
That was what he said.
Driving pattern, smelling alcohol, your client's admission that he had had multiple beers, I think 2.5 is what he conceded, being in the wrong place
That
is...
came,
Well, didn't that come out at the McDonald's? or
it did,
not?
but he also explained being lost. And again, the officer didn't say that counted as part of his belief that he was impaired until after the defense attorney asked him. So that's the problem, is a lot of that stuff that the court is referring to and that the jury was told in closing argument was evidence that was elicited by a defense attorney who had prior knowledge, who admitted he never spoke with the first woman, who, and I don't know if you noticed this, she said she followed him for 30 minutes, and they talked about that, but the 911 call is about 7 minutes, and she said she watched him for 2 before that. We didn't hear about that either. So the problem is there was essentially no defense put forth in this case. If you read the transcript, there is no affirmative defense, none at all. There is no testing of the state's case in this transcript. That it is basically the state was able to turn it into a referendum on how unsafe it is to children in the crosswalk for people to drink and drive or have any alcohol, that the prosecutor who told the jury in jury selection it's important to have somebody with training and experience to help us know what's impairment, and then tells them no less than 10 times in closing, he was impaired, he was DUI, he was impaired, he was so impaired, he is guilty. Not, I think that's what the evidence will show, I think that's what we'll see, and I see I'm in my rebuttal time.
All right, thank you, Ms. Cohen. You'll reserve the rest of that time for rebuttal. Mr. Lawden, are you prepared to proceed?
Yes, Judge.
When you're ready.
Your Honors, Counsel, may it please the Court. Zach Lawton for the State of Florida. Williamson begins his reply brief, regardless of the arguments and factual recitations put forth in the briefs in this case, the actual record is the best argument for reversal. And that's exactly the problem with his motion. He points out things that counsel could have done differently, makes a boilerplate argument for prejudice, and then kind of expects the courts to dig through the record and figure it out regardless of the arguments and factual recitations in the motion and the briefs. The question, of course, before this court is whether the trial court erred when it denied Williamson's motion, not whether there may be evidence somewhere in the record that may show ineffective assistance of counsel. But let's talk about that record. Now, it's easy to play Monday morning quarterback, but when you read the record, what you don't see is any evidence that counsel was not functioning within the wide range of reasonable professional assistance, which is what Strickland requires. The record does not show a defense attorney who is incompetent or just phoning it in. It may show that in hindsight, certain questions could have been asked differently, or evidence could have been presented differently. But Strickland requires reasonable professional assistance, not perfection. It also requires a probability that deficient conduct affected the outcome of the proceedings. Now, that's the big picture, and I want to talk about 4 big picture things before getting to the specifics. First, a big picture, it's important to look at the pleadings. The pleadings were very factually based. This happened, without much argument as to why anything was deficient. And I think that's important because that's what was before the trial court. The second big picture thing is prejudice. I want to read, in the original motion, this was the entire argument on prejudice, and it's page 10 of the motion. I'm not sure what page of the record. It says, the transcript of the trial shows that breath test results The breath test result was the focus of the trial. Now, the state would disagree with that because there was no breath test result, and the focus of the trial seemed to be Williamson's driving. But then after that, the above actions and inaction by defendant's trial counsel was so deficient that he was not functioning as the counsel guaranteed by the Sixth Amendment, and the deficiency served to deprive the defendant of his right of the fair trial. The defendant has suffered prejudice, as there is a reasonable possibility that but for counsel's error, the result of the proceeding would have been different. This probability is sufficient to undermine confidence in the outcome. That's completely boilerplate. There's no explanation at all of how any of this deficient performance prejudiced Williamson's case. The third big picture is look at the evidentiary hearing. Williamson often just failed to meet his burden at the evidentiary hearing. We have a lot of arguments that require evidence. The deputy was not called at the evidentiary hearing to testify. Williamson did not testify at the evidentiary hearing whether he felt that he could leave when the deputy parked behind him. There's no evidence in the evidentiary hearing about Williamson's medical issues. There's no expert testimony that someone with his medical issues could not have done a field sobriety exercise.
Why did it matter that the detective was not called at the evidentiary hearing? Why, from the state's perspective, did that matter, and why was that dispositive?
Well, we have arguments in the brief about what the deputy knew. And there's an assumption that because maybe one 911 call or one dispatch call didn't have certain information, that the deputy also didn't have that information. But if the deputy were called, the deputy could explain whether maybe there was another call. The deputy could say what information he actually had at the time.
Was that dispositive, the deputy not being called?
Well, if everything were taken to be true that Williamson has argued, then I think it's still important what information the deputy had, because if the deputy, so they say, well, the deputy didn't have the license number because that wasn't in the dispatch call. Well, if there was another call that gave the deputy the license number, or if there was another way that the deputy knew the information that was in the original 911 call, then that certainly would be important in a motion to suppress. And that evidence would not have come out at trial because it all would have been hearsay. And the fourth big picture item is Williamson talks a lot about the recklessness becoming such a feature, such a theme of the trial. But Williamson has not answered the Brown case, and Brown was referenced in the answer brief. It's a 5th DCA case that says that reckless driving is an indicator of impairment. And so saying that his driving was reckless and dangerous was certainly relevant to determine whether he was impaired. Now, on the specifics, I'd like to focus on the grounds that were argued in here and rely on my rely on my brief for the other grounds, unless your honors have any questions about them. So first, looking at the B ground. The lack of objection during voir dire. Now, what we heard was that there's never any follow-up question to explain what some of these questions were about. When counsel asked about the dangerousness or whether you've encountered aggressive drivers, things like that.
Mr. Lawton,
yes.
You stated in your brief that defense counsel conducted a thorough voir dire. What exactly do you base that on? Can you give some examples?
Well, he certainly if Your Honor could give me a minute. Well, he asked the jurors about some different topics. Now, they suggest that he should have asked about more different topics or other topics, but they never explain what topics should have been addressed. Let's see. And off the top of my head, I'm not remembering anything else specific from the voir dire. The crosswalk issue was certainly harped on. I think that this is another example where there's just no way to show prejudice, because what happens if counsel were to object to the crosswalk question? Then we have the question out there, is an impaired driver a danger to kids in crosswalks? And then there's an objection, so the jurors have heard the question, you can't unring the bell. But what do we get when there's not an objection? We get the response from the juror, which is, oh, our kids aren't in crosswalks. So there's no evidence there that the juror was inflamed in any way. The juror simply said, oh, that's not really an issue, we're not worried about that, which was much better for the defense than had there been an objection and the court made the state withdraw the question. And it was important to find out the jurors' feelings on...
And to understand what you're saying there, a lot of times it's more deleterious, detrimental when a question is not answered, because then the potential jurors may think about what the answer would be, and you're saying here the answer was given, it eliminated the problem, and so it turned out to be sound strategy by the defense attorney.
Yes, Judge, I would agree with that.
All right.
And it was also important to find out the jurors' potential bias about driving under the influence. That bias can go two different ways. You could get an answer from a juror that, well, DUI doesn't seem like such a big deal to me. You have a few drinks, you drive. As long as you don't actually kill somebody, it's not a big deal. The state doesn't want that juror on the panel. But at the same time, you could also have a juror say, well, my brother was killed by a drunk driver, and that could lead to questions about, well, do you think you couldn't be fair and unbiased? And the juror may say, yes, I don't think I could be fair because this is too important to me.
Isn't there an argument, Mr. Lawden, that oftentimes in jury selection it's better to have more information than less for the reason you just said, so you can evaluate whether potential jurors can be fair and impartial?
Yes, Judge, and in the crosswalk question, that would have been very important to find out whether that teacher had a specific bias about DUI because of worrying about the children in crosswalks. And
so that's why a lot of good trial lawyers ask open-ended questions in voir dire.
yes, Judge, and open-ended questions can, in both voir dire and in trial, they can find out information that can be helpful that may be unexpected.
And I guess my focus is on voir dire because, again, if you're defending a case, if you're on behalf of the state prosecuting the case, it helps to have more information in order to evaluate the objectivity of that potential juror.
Yes, Judge, and that information can come from questions asked by the state or questions asked by the court or questions asked by the defense. And I think, speaking of kind of open-ended questions, one of the arguments that is made by Williamson is that there's absolutely no possible reason to in the cross-examination of the officer, to question him and say, well, what were the other indicators of impairment? And I think that's another case where the jury's imagination could be an issue. The testimony in direct by the officer was that one of the indicators I saw was that I smelled alcohol in his breath. That implies there are other indicators, and the jury hears that, the jury's imagination starts going, and they think about what the other indicators could be. And the other part, so it's important for that reason to establish what those indicators are, because you don't want the jury thinking about what else the officer might have seen that might have been a reason to convict. The other thing is that defense can't answer those indicators without knowing what they are. And so if you've got this kind of nebulous answer that there are other indicators and the jurors are wondering what they are, you can't get up in closing argument and argue that those other indicators are not evidence of impairment if you don't know what they are. So it was important to the defense to get that information, even though it may have at some point been hurtful to get some of that information. For example, the argument being made that it wasn't much of an indicator that he saw Williamson walking into the McDonald's. Well, that's not an argument that would have been made and couldn't have shown that, well, this is a bad indicator if that evidence hadn't come out. And okay, well, so in general, what we have is a complete inability to state what prejudice was. We have a very boilerplate explanation of prejudice in the motion, and what we have in the end in this case is we have Williamson's admissions that he was driving and that he had been drinking. We have the 911 caller's observations of his very reckless driving, and that is an indicator of impairment. And we have his confusion. He's going the wrong way. He's going away from the airport and says he's going to the airport. Also his confusion, he thinks that McDonald's is open when it's not. And of course, the officer smelled alcohol in his breath. Those are, that all very strong evidence of DUI and certainly gave probable cause for an arrest. If there are no other questions, I'd rely on the briefs.
Thank you, Mr. Lawton. Ms. Cohen, rebuttal?
Yes, sir. First of all, I don't believe, and I would disagree, that it's good strategy to bring out as much negative evidence as you can about your client so then you can try to refute that evidence in closing. In closing, the proper thing would be the only thing you heard today was the odor of alcohol. That as the judge will instruct, you have to base your decision on the evidence before you.
But what about the notion, and I just heard it from Mr. Lawton, that during voir dire you want transparency. You want potential jurors to speak, correct, Ms. Cohen?
Correct, but the problem is not what the question, not even just the questions, it's everything the state told them. And then there was, again,
let me stop you there. In my experience, having tried cases as a trial judge and a trial lawyer, and now as an appellate judge, a lot of times when the jury doesn't hear the answer to the question, it causes more questions. So wasn't it potentially efficacious here that they were allowed to answer those kind of questions?
The problem is when it started going down that road, the proper thing to do, I would suggest, is to approach the court and say, we're going down a road that is not proper here. So before the rest of the questions get asked, so you don't even get to the point of children in the crosswalk, that originally and initially an objection, an ask to approach the court. Same thing with the 9 comments about reckless driving. If you object the first time and you address it, or even the second time, and you address it, you don't have to do it presumably 12 times or 10 times or 9 times or however many times. The problem is if you're not objecting from the beginning, then it just continues and it continues. If you look at everything, in terms of first of all, in terms of responding to some of the procedural issues, obviously those were not raised below. There was never question about the sufficiency of the motion. There was a hearing. I realize there was a typo in the original motion. There's a typo in one of the briefs that the state wrote about the standard of review on a summary denial, which this wasn't. This isn't about any of that. This is about the evidence. The motion outlined factually what the issue was, didn't repeat in every single paragraph this prejudice, because the issue here is not isolated comments, and it's not minor or brief situations. It is that the overall picture of what was put in front of the jury so compromised the jury's ability to fairly evaluate the evidence in front of it. No one ever asked the jurors how any of what they heard affected their ability to be fair and impartial. No one ever said, do you think that your concerns about DUI would cause you to be fair and impartial? They talked to the people who had family members or who said, I think police would be more honest. But in terms of field sobriety exercises and the state telling them they're a really good test of if somebody's impaired or not, all of that, there was no follow-up. There was no questioning about whether or not that impacted their ability to sit and be fair and impartial. So nobody learned anything from that because there was no response from the jurors as to how any of that would impact their ability to sit in their case. This is not a case where it's a nuanced claim of ineffective assistance. This is almost an in-your-face claim in terms of how it started with everything that was stated to the jury in jury selection to the very ending where the very last thing stated to them was he could have killed somebody, which is not an element of the DUI. In terms of the error, again, I think that we've laid out all the errors. I know I haven't mentioned all of them today, but they're in the briefs, that Mr. Williamson did meet his burden, that the trial counsel really had no explanation for anything he did other than, I think, maybe, or the thing that the court has raised about, isn't it sometimes wise not to object? And yes, it is. But by that token, if you carry that theory over, then it would never be appropriate to object because you either want to bring out bad information so you can make sure you can rebut it, or you don't want to stop the trial, or you don't want to look bad in front of the jury, but clearly, sometimes you just have no choice. And this was a clear case, number one, of where you had no choice. And then to say that it's good to learn new information in a trial, I think that in and of itself, if that is the strategy, if you're in a trial as a defense attorney, trying to learn new information at that point, that in and of itself is a problem. And I'm done.
All right, thank you. I'm not sure why we're beeping, but that may be operator error on my part, Ms. Cohen. But I'll give you 10. I'll give you 10 seconds to close.
I'm done.
Thank you. Thank you both. We are going to take a brief recess ahead of our next argument. Why don't we plan to be back? I think we were set anyway at 11:30. So why don't we plan to be back at 11:30 for the next oral argument? But thank you both. It was professionally carried out as I knew it would be. Good to see you both. It's been a while, and we'll be in recess until 11:30.
All right. I'll fix that.
Thank you.
All right.
Please be seated. We're here for our second live case of the morning. This case is Hudkins versus Hudkins, case number 21-3094. Mr. Hauser, you may proceed. And if you'd be kind enough to let the court know how much time you would like for rebuttal.
Okay, thank you, sir. 20 minutes, huh?
You have 20 minutes total, but how much would you like to reserve, if any? Some don't reserve any.
7.
7 for rebuttal?
Yes, thank you, sir. And may it please the court, my name is Robert Hauser. I practice in West Palm Beach at Sniffen and Spellman, PA. And I represent LaDonna Hudkins, who is the wife in this situation. She's the spouse of an alleged incapacitated person. His name is Keith Hudkins. Sometimes I'll call him the ward. The most important issue today for us is the marital home. The evidence in our case is incredibly simple. This marital home was acquired in 2019, if I'm not mistaken. It was taken in a deed as entirety's property. After the husband had an incident that may have caused him to be incapacitated, we don't concede that he was, but after that incident, the wife used a power of attorney to transfer that house to a trust entirely controlled by her, and there's no question.
So you're saying you're not conceding that the determination of incapacity was proper?
That's true.
Okay. Did you attach the order of incapacity to your notice of appeal?
Not the August 26th order. And it's, by the way, it's too late for us to attack the decision of the trial court to call Mr. Hudkins incapacitated.
So you're not, the issue that is raised in your brief is more to deal with the property transactions, not with whether he is, as I read it in your, I think it may have been in your reply brief, you're more interested in these Medicaid transactions and the property transactions as incapacity rather than the finding of incapacity and the appointment of the guardian. Is that correct?
Right, and I don't think the court has jurisdiction to review the order that actually declares him incapacitated.
Okay, I would agree.
Yeah,
Okay.
my problem is the weaponization of that determination in what is really an in personam lawsuit against my client, because, and I do want to get to that incapacity determination if we have time. I think we're going to have plenty of time, 20 minutes. But the marital home is the most material thing here. As I said,
So the marital home was titled as tenancy by the entirety?
Yes, sir.
Correct?
Absolutely
Okay.
right. And then
And your client
She transferred
transferred it to herself in her
trust.
in her trust.
And the
Correct?
court, yes, sir. And the
Okay.
court frowned on that. There's no question that the court frowned on that. I don't think that was before the court.
So what are you asking the court to do today? Give the home, since she titled it in her name, to her, or back to tenancy by the entirety?
Well, you could do one of two things. I think the technically correct thing is that this guardianship court didn't have jurisdiction over my wife's, my client's trust's property at that hearing. That hearing was about whether the ward needed a guardian and who that guardian was going to be, assuming that he's incapacitated. And instead, it sort of morphed into an unnoticed in personam claim against the wife. And that's really where the error is here. It wasn't really the judge's job at that hearing to decide what happens to the house, because it wasn't guardianship property. Now,
Was that ever brought up in any, I know there's multiple hearings in this, I was trying to follow the multiple hearings that you had. Was that ever brought up or argued below as to what would happen to the house? Did you ever have the opportunity to argue as to what would happen to the house below?
our trial lawyer did not raise that specifically. It came up in the other side's closing argument, and they put in a request at the end.
I understand it came up in the request. I'm talking about in the proceedings, other than the closing arguments, was there ever any litigation over that property? that you were...
The facts came in. The facts are known, and those facts were relevant to determine...
Was there ever any litigation about the determination of how this house would ultimately be titled?
I don't think so, but the fact that my client titled the house from entireties into
Why
this
is
trust...
it not waived then, Mr. Hauser, that issue?
Because I can raise the sufficiency of the evidence on appeal for the first time. And I'd like to talk about what the evidence is, okay? The evidence is it was entireties property. The evidence is that it was moved to my client's trust. And the evidence is that the court frowned on that last transaction, right? And so let's assume that we waived everything and that we walked into court and waived any objection to litigating over that last transaction, okay? Let's assume that my trial lawyer blew it and he also didn't file a post-trial motion, okay? Let's assume he blew it. The evidence in the case is that that property goes back to entireties property. The evidence in the case is not mandatory permanent injunction, give the house to them.
So can you explain then, I guess what you're arguing is that there was fundamental error by the court, and that's what brings that in front of us to hear?
Yes, sir.
Can you explain that?
I think there's a due process problem because this was noticed as a hearing over who's going to be the guardian and what are their powers going to be. That's a due process problem. But let's assume that was waived under Rule 1.530.
But you would agree you can waive due process, correct?
I can't imagine.
You can't imagine?
Due process is fundamental error. If the denial of due process is fundamental
Why
error.
can't you imagine, I mean, if I am, hypothetically, I'm called to a hearing, and the judge starts talking about something I didn't prepare for, is there not an obligation either to bring that up in front of the court, or to file something after it, or to file something to let the court know that it was different than what you anticipated it to be? Or is it just enough to sit on my hands and wait for appeal and say, well, my due process rights were violated?
I'm not familiar with a case that says that if a judge suddenly rules at the end of a case on something that was never before him, that you have to go back to that judge and say, you know what, that wasn't what we were arguing.
Well, let me ask you, so following up on Judge Jay's question, we also have the condo proceeds, which obviously it appeared everybody thought was going to be argued at a subsequent hearing after the final hearing that you had. All of a sudden, it shows up in the closing arguments by the guardian, and then eventually the judge puts that same language in her order, correct?
Right, and it's the same analysis.
So there was a hearing set, though, and then by your client, there was a hearing set, and so she canceled that hearing. How is that, along with the fact that this was in the closing arguments and there was no response to the closing arguments, how was that, following up on Judge Jay's question, how is that not a waiver at that point? And you had an opportunity to file for a motion for reconsideration or rehearing, and that was never done.
Okay, let's assume that we waived due process and it's not fundamental error, okay? I still have Rule 1.530, which is, and that's really the reason I'm telling you what the evidence is in the case.
So does 1.530, though, apply to guardianship proceedings?
Why not?
Because there's a rule in the guardianship rules that discuss that unless a rule of procedure is in the guardianship rules, that we don't apply those rules of procedure. And 1.530 that I can find is not in the guardianship procedures or in the probate procedures. Can you address that?
Yes, this is an adversary proceeding. I mean, it turned into an adversary proceeding when they tried to make in personam rulings against my client. So you can see sort of the circular problem here. This was...
So I want to make sure I understand that, Mr. Hauser. So you said it turned into an adversary proceeding, and by virtue of it becoming an adversary proceeding, it became a regular civil matter at that point, and then the rules of civil procedure would then apply?
Right, because we're not talking about in rem anymore. When the judge entered a mandatory permanent injunction against my client, saying you have to hand this property over, not just the half that used to belong to the ward, which I could see happening in a future proceeding, Your own interest in the property also must be handed over to the ward. A complete forfeiture of her marital constitutional homestead interest in her marital home is gone. And that was all done by surprise, okay? And so to me, that is a due process violation, but the evidence in the record is clear that if the transaction is voided from entireties to her alone, if it's voided, fine, then it goes back to entireties, and my client still has her marital homestead interest in that house. And the exact same...
So let me ask you about the tenancy, the Ponte Vedra home, and then I want to ask you about the condo fees, kind of the same. The Ponte Vedra home, are you arguing in your brief that that needed to be a separate legal action, that they needed to get permission to file a separate legal action? That should have been a separate legal action under Florida Statute 744.441K? Is that...
No question. No question. But let's assume we waive that.
So as to following up on that, as to the condo. So the condo, prior to any finding of incapacity, I think the facts showed, the condo was held tenancy by the entireties, then it was put in a joint trust, is that correct? Or was it sometime put into a joint trust, correct?
It was never entireties property. It belonged to the ward, and he put it in a trust where he and the wife were together.
Okay, so are you here today saying that the judge was correct in ordering that all those funds from the sale of the condo go into the guardianship account? Are you not contesting that?
No, that's error. Those are trust funds. They're not part of the guardianship estate. The evidence in the case is exactly, I think, as Your Honor just recited. They were trust funds. The wife transferred those to a trust that only she controlled in order to sell the house. And again, it's just like the house.
She sold that during the proceedings, correct?
Yes.
So the judge, I think the judge gave her permission to do that?
I don't think the judge stopped her. What the other side was interested in doing was intercepting the proceeds, and the court did intercept the proceeds. My point today here
so are you saying that there needed to be, since the judge, everybody knew the sale was going through, the judge took the proceeds, that there needs to be a separate independent action for that, or just that you didn't get an opportunity to argue that your position as to those funds?
It is technically true that there should have been a separate proceeding to grab those funds, but let's assume that it's okay.
But they may waive that below, correct?
Let's assume that was waived.
Okay.
The evidence in the case is that those funds originate from a joint trust, and if my client was wrong to move it into a trust in order to facilitate the sale as part of the Medicaid planning...
Okay, so then that brings me back to the same question I had before. At the end of the proceedings, there was some discussion by trial. You were not trial counsel below, is that correct? So there was some discussion by trial counsel below asking the judge right at the end of the proceedings, what are we going to do with these funds? And she says, put them in let's put them in the closing arguments. I believe even maybe the ward's attorney spoke up and said, no, we've got a hearing here in a week. And so I guess my question is, you had this hearing that was supposed to be to dispose of these or resolve the issue with these funds, and then it gets canceled. Do you know why it got canceled?
I do not.
Did the petition actually, not only did they cancel, did the petition get withdrawn for those funds? Do you know?
I don't know. And as far as I can tell, it was litigated in that proceeding, and the judge decided...
So your sole argument for those funds today is that you never had an opportunity to be able to argue where those funds would go below?
No, sir, because the judge evidently doesn't need to hear from us. But there is evidence in the case, and the evidence is not disputed.
But there was an opportunity at this hearing, Judge Boatwright just referenced, which was canceled, as I understand it, based on this record, by trial counsel. So the opportunity to deal with the very thing you were arguing on appeal was available, and it was taken away by virtue of the cancellation. So why is that not a waiver?
Because the evidence is in, and the judge made a decision based on the evidence, and the evidence that is in shows that this condo was joint property. It's not guardianship property. There's no evidence that it is guardianship property.
So all of this emanates, and I want to make sure I understand, and I think you said it at the beginning, but if I'm misinterpreting what you said, please tell me. that all of this emanates, these 2 points that you're discussing with us now, emanates from the insufficiency of the evidence to validate the court's ruling. And insufficiency of evidence is always something you can argue on appeal. Is that what you're telling us?
Yes, sir. And the evidence in this case, the judge is wrong. The judge is wrong to say that my client has to give the entirety of the house to the other side. In the worst case scenario, she has to give the half of the house that was their entirety's interest to the guardianship. That could have been guardianship property if her subsequent deed is invalidated. The evidence in the case that was before the judge is that the condo was in a joint trust. No one's attacking the existence of the joint trust as illegitimate. The evidence in the case is that it's not theirs. The evidence in the case is it belongs in a trust.
Is there a difference between tenancy by the entirety's property versus something being a joint asset? Doesn't the guardianship court have the ability to take joint assets and give them to the guardian for the benefit of the ward?
Not without worrying about the rights of the other trust beneficiary and trustee, and that would be in a proceeding. Like, I agree, this guardianship court could have reached into that trust and accessed some of that money, but not in complete disregard of my client's rights in that same trust. And then the house is more egregious, and I think Your Honor's onto that. The house is more egregious because the house is our entirety's property. If the transaction from entireties to sole trust is invalidated, it goes back to entirety's property. It's my client's house. It's hers. And so and there's a statute that limits the alienability of entirety's property as between a guardian and the other spouse.
Not that you need my warning, Mr. Hauser, but you're well into your rebuttal time. But I'd leave that to you if you want to proceed.
I see it. I think you understand the property issues. The last issue is incapacity. It's one thing to use this new statutory procedure to put somebody in guardianship where their own appointed attorney doesn't object. Okay, and that happened here. The appointed attorney did nothing to stop this person from being put into guardianship, and we didn't have standing, according to their own arguments, to stop it. That is one thing. But then this same hearsay-based incapacity issue is used at that trial, and this is an objection that we made vociferously at trial. Those reports are hearsay, and yet they were not only admitted to shut down the ward and put him in guardianship, they were used to make these determinations about my client's property in personam against her. And that's error. That is a due process problem, which is why her objection should have been sustained. You can't use that incapacity determination as a weapon against somebody else, even though it's waived against the ward.
She did have an opportunity to go to that hearing. She is an interested party, correct?
Of course.
Okay, so she had an opportunity to go to that hearing, correct?
Of course.
Did she subpoena any of those doctors to testify as to whether he was the incapacity issue?
No.
She had that opportunity, correct?
Theoretically.
Okay. All right.
But it's not my client's burden to prove incapacity in any respect whatsoever. It's actually somebody who's trying to take her property away on the grounds that a transaction was invalid because of his incapacity has to prove incapacity by clear and convincing evidence. There's nothing in the statute that shifts that burden to my client. All my client has to do is put them to their proof, and they only had the hearsay reports, maybe good enough against the ward, not good enough to invalidate third-party transactions against a spouse, business partner, contracting party, donee. And imagine all these people out in the world who are doing business with alleged incapacitated people. They can't be bound by a hearsay admission of a report in a court like that. It's hearsay, and it's only binding against the ward, not against the outside world. Thanks very much.
We'll keep the 154 for your rebuttal, Mr. Hauser. Is the appellee prepared to proceed?
I am, Your Honor. Thank you. Good morning. May it please the Court. My name is Keith Cromash with the law firm of Nash & Cromash LLP in Melbourne, and we represent Dr. Matthew Hudkins, the appellee in this case, who is the plenary guardian of the person and property of the ward, Keith Hudkins. I'd like to begin by correcting a misstatement on the part of the appellant in their reply brief. And I think the court may have picked up on this, but it was alleged in the reply brief that me, as trial counsel, and my client submitted the proposed order to the judge that is being reviewed today. In fact, I didn't submit that proposed order. What happened was the judge requested the parties to submit closing arguments. The parties did submit closing arguments, and the judge prepared her own order. I had nothing to do with that order in terms of writing it.
You did place the request,
Yes.
though, in your closing arguments for, let's just say, for the condo fees when that had not been litigated, had it?
Well, to your point, or I think it was, yeah, Judge Boatwright, you asked the question of whether the property issues had been litigated. And I do want to point out that we filed an emergency motion for authority to initiate legal action, an emergency motion for temporary injunction. That's on the appellant's, or the appellee's appendix, but on pages 9 through 26. That sought to invalidate the memorandum of trust with respect to the Ponte Vedra property, and I think it also, I want to say it also requested a injunction with respect.
So I saw the motion or the
Yeah.
petition. I guess the question is, were those issues ever litigated?
Yes, they were, and it was, if you take a
Was there
look.
ever litigation giving his client the opportunity to dispute how, let's just say the condo fees in particular, how those condo fees would be distributed?
Yeah, so that hearing, this case, as you know, went over months, and it was many days. We set the hearing for this issue about the property, and we litigated it for the entire day, and it concluded without, or it ended without concluding. There were 3 witnesses who testified at that hearing. There was the ward who testified, attorney David Jacoby testified, he was the Medicaid attorney, and the appellee testified. So granted, the appellant didn't get her opportunity to testify, but if this case had gone on and this hearing had been allowed to continue, she would have had that opportunity. But she certainly had the opportunity to participate. And by the way, David Jacoby was her witness. So it's not as if she didn't have an ample opportunity to participate in the proceedings.
So let me ask you about the Ponte Vedra home specifically. So it was titled as tenants by the entireties.
Yes.
Then, contrary to Mr. Jacoby's recommendation to her, she then records the deed, placing it in her own trust, correct?
That's correct.
Okay. So she was in error, let's just say she was in error there, but wasn't the judge in error giving that property solely to the titling it in the guardian's name solely for the ward? Shouldn't this have gone back to tenancy by the entireties?
Well,
And I guess in following up on that, why would you request that in your closing arguments? Is
Okay.
there some legal authority
Yes.
for that? Okay.
and this is what we argued in the brief, and what I contend today is that, first of all, guardianship, as the court knows, is an equitable proceeding. That's the Hayes versus guardianship of Thompson case out of the Florida Supreme Court. So we know it's an equitable proceeding. We also know from Hayes that the protection of the ward is the overwhelming public policy of guardianship law. So that's sort of the basis for where I started. So the trial court's ruling was both an equitable and legal ruling. And then in addition, as far as legal authority, Section 744-361-12 specifically includes pre-guardianship assets in property that the guardian shall, with court approval, take possession of.
So I'd agree with you on that, but we also have 744.47 or 4571A that the appellant cites to discussing tenancy by the entirety of property. I'm going to just read you the last sentence. If the spouse who is not incapacitated joins in the sale, transfer, conveyance, or mortgage of the property. So if that happens, you can transfer the tenancy by the entirety's property, but she did not do that here in this case. So I'm not clear how you're saying that. I understand you're citing this statute and the guardianship rules, but what legal authority do you have to take tenancy by the entirety's property and give it to the guardian? I might be more persuaded on the condo fees, but what if you can point to some legal authority that gives you the ability to take tenancy by the entirety's property and give it solely to the guardian for the benefit of the ward, I'd be interested in hearing that.
Yeah, well, the case that I cited is the McGilton versus Millman case. That's in our brief. It's a 4th DCA case, and in that case, the guardianship court had the authority to rescind a transaction that occurred before the guardianship.
But that was not tenancy by the entirety property.
That wasn't, and I admit that this issue may not be the strongest issue for the appellee. But one thing I do
Same
want...
case, though, also, which is a little little confusing. They do say they can rescind, but then a couple of paragraphs down, don't they discuss the fact that you need to file an independent legal action to do that?
Which we did, and which wasn't fully heard. So
Did you actually file, so you did get permission and filed an independent legal action in this matter in regards to the house and the condo fees?
well, I would say that we asked for permission by filing the petition, and the court granted the permission by entering the order. So,
But did the court grant permission to pursue the action, or did the court resolve the action?
well, the court, in this case, the court resolved that action.
And is that proper?
I think it is, based upon the authority I cited, but to the extent it's not, there's another aspect to this I want to raise, but to the extent it's not, then the appellant may be correct in that it should go back to T by E, tenants by the entireties. But I do want to point something out, and it's important, because I think where these questions are going is, why didn't we concede error on that point? And I know there's a motion for sanctions pending, and I want to address that. The reason we didn't concede error on this point goes to the capacity issue. If you look at how this brief was, the initial brief was framed, the very first issue on appeal is the trial court erred in finding the ward incapacitated over the appellant's hearsay objections. This despite the fact that the order, as the court pointed out, wasn't even attached to the notice of appeal. And the issue of capacity permeates the entire appeal. In fact, the appellant argues in his brief, or in her brief.
How does the issue of incapacity, though, fall into this idea that you can take a tenancy by the entirety's property owner? And again, I know she should not have, the court said she shouldn't have transferred that. But how does this issue of incapacity then give you the legal authority to then place that solely in the name of the guardian?
It may not, but what I'm speaking to, Your Honor, is why it was necessary to defend the lower court's order in the way that we did. And the reason it was is because this entire appeal was premised on incapacity and the request for relief from the appellant. And I'm pleased to hear that the appellant say that they're not asking to overturn the whole guardianship. But when you read the initial brief, that's exactly what they were asking for. They were asking for basically to terminate the guardianship, to remove Dr. Hudkins as guardian, and basically start from square one, including starting from the finding of incapacity. And that's clearly, I think, improper. I think the finding of incapacity was entirely correct. I don't think there wasn't any error on the part of the judge in that regard. So it was very important to protect the ward and to protect the guardian's obligation of protecting the ward for us to argue that the trial court did not err. And certainly, if there was an error in that order, it wasn't the entire order, but that's the relief that the appellant was asking for, is that reversal of the entire order, not just the portions of the order that they found objectionable.
Okay, so in regard, let's move. I'm going to just ask you a couple of questions about the condo fees.
Okay.
So with the Ponte Vedra home, obviously the title has now been placed in Ms. Hudkins' name, correct? So that title would have to be through a separate legal action, potentially to be transferred back. What about the condo fees themselves? Were you asking to file a separate legal action in regards to the condo fees, or just in regards to the entirety's property?
Well, the separate legal action was only related to the Ponte Vedra property.
Do you think you need to file a separate legal action since that property's already been sold in order to resolve the fee issue?
I don't, and I think, and I'm not sure which of your honors asked the question, but this was addressed during the hearing, and at first the proceeds, because it was sold before the guardianship started, or maybe it was during the guardianship, but the proceeds were at first placed in the appellant's attorney's law firm's trust account, and then after that attorney withdrew and the subsequent trial attorney took over, the court authorized and ordered that the appellant put the proceeds of the condominium in my law firm's trust account, where they were until the conclusion of the guardianship.
Are you aware why the hearing got canceled to resolve the issue with these these amounts?
Yeah, I'm racking my brain on that. I can't recall why it was canceled. I don't know if it was something on our end, or if it was the appellant's end, or if it might have been the court. I just don't know the answer to that, Your Honor. What I would like to talk a little bit about with my remaining time is the capacity issue. We cited 744-331-3I in support of what the court did, which is to allow the committee reports to come into evidence over the hearsay objections and allowed to be used as substantive evidence of incapacity. And this was entirely correct. As I made, or as I analyzed in the brief, the 744-3313I is a relatively new statutory provision. It was added in 2017, and it was a reaction to the Shen case. In the Shen case, the court said that the committee reports are hearsay and that they can't support a finding of incapacity over an objection. And so what happened was the legislature looked at that and it came up with this procedure where only the appellant, or I'm sorry, the AIP or the petitioner has standing to object to the reports. And at that point, they have to do it in writing within 5 days prior to the hearing. And if you don't do it that way, then the reports can come into evidence. And the analysis that we did, including the staff analysis from the House Judiciary Committee, from the staff analysis from the Senate Rules Committee, as well as other committees, shows that this was the thinking of the legislature in coming up with this statutory scheme. And to the point that the appellant makes that, he had a due process, or the appellant had a due process right to object to the committee reports as hearsay because somehow they were used against her, which I want to address that issue also because I don't think that's the case. But the statute, 744-3313H, which existed before the change to 3I, says that the clerk is only required to serve the committee reports on the AIP and the petitioner, no one else. So it makes sense that only the alleged incapacitated person and the petitioner has the standing to object to the committee reports. That's in the statute. So I think it was entirely appropriate for the lower court to find that the ward was totally incapacitated based on the committee reports. And in addition, the argument that the committee reports were somehow used against the spouse, I think is spurious. I think it's speculative. At the hearing on the capacity is a separate case number. The only issue, in other words, that's an MH case number, and you have the guardianship, which is a GA case number. They're totally separate cases.
I think he's already kind of made the point, though, that we don't have jurisdiction. He's agreed to that. I understand his other argument, but I think he's.
He has agreed to that, but my point is that the argument is being made that it was admissible as to the ward, but it's not admissible as to the appellant. That's the argument he makes.
In fact, I believe appellant even argues that they're entitled to litigate that de novo on any sort of action that would follow as it pertains to the interim jurisdiction, right?
That's what they say in their brief, correct. And frankly, I think that's a stretch, to say the least, because, first of all, again, the capacity issue, at the time capacity was being litigated, the spouse's property and the spouse's interests were not even being considered. That wasn't even a factor in the litigation at the time. The only issue before the court during the capacity proceeding was whether the ward had capacity. And at the time, the spouse raised her objections. She said they were hearsay. She argued as hard as she could. But the trial court, I think, got it completely right, relying on 744-3I, and said, yeah, the reports come in, and the trial court could rely on them as...
So your contention is that the appellant did not have the standing to object to the reports on the hearing pertaining to capacity, correct?
Absolutely.
Your fallback or alternative argument is even if the appellant did have such standing to object, they were bound by the requirements of the statute to put it in writing 5 days in advance so as to allow you then to summon the or subpoena the doctors to be present so you can meet your burden.
Exactly. And that's the whole...
They're not permitted to lay in the weeds and wait, object at a hearing, and then you didn't subpoena the witnesses believing that no objection was going to be presented subsequent to statute.
That's exactly right. And that's what the legislature, I think that was the thinking of the legislature.
Statute, in particular, you would agree the statute just says petitioner and then the AIP's attorney, correct?
That's correct.
It does not mention any other, I think that's their argument, is it doesn't mention anybody else.
Well,
so the statute specific on the two parties that are to file the 5 day, the notice within 5 days. Is that correct?
Well, I think the argument is because, I think the appellant's argument is that because the statute only lists two people and requires those two people to comply with the 5-day rule, then anyone else can object and is not required to follow the 5-day rule. I find that argument to be not persuasive because, well, first of all, the rule of statutory construction that says when the legislature specifically lists items, they intended to exclude the items not listed. That's a pretty basic rule of statutory construction. And plus the other factor that I argued earlier, which is that in the 744-3313H, which is the statute dealing with the service of the reports, you're only required to serve on the AIP's attorney and the petitioner. If those are the only two individuals that get service, then how can it be said that people that aren't entitled to service are entitled to object, especially when the statute is specific as to the individuals who are entitled to object?
I want to give you some opportunity. We raised some issues. We asked the appellant some questions on preservation, in particular the two issues that seem to be most hotly contested here, the funds from the condo and the Ponte Vedra home. Do you want to speak on whether they have preserved those arguments for appeal?
Well, yeah, I mean, absolutely. We certainly made the argument in the brief that at the conclusion of or after the trial court entered her order, rather than filing a motion for reconsideration or a motion for rehearing, the appellant went right to appeal. I do believe that they certainly had an obligation to raise this issue with the trial court. If this
Why is that? You have authority for that case?
Well, it's just basic preservation and basic concept that you need to give the trial court the opportunity to rule on an issue as a basis before you can appeal it. Now, I heard what counsel said about Rule 1.510, I believe it is.
530, which is the rehearing rule in the civil realm, which Judge Boatwright pointed out may not even apply to this proceeding. But what say you about that? If the rehearing rule doesn't apply, was there still an obligation to file, and you mentioned a motion for reconsideration, something to bring it back in front of the trial court?
Again, I think well, to your point, I don't know the answer whether the rule of civil procedure applies in this case. I think it's possible that it does. I think counsel's argument that this was a adversary proceeding is correct, and therefore the rule of civil procedure may well apply, but I haven't specifically researched that issue. But to the point that I'm sorry, what was the question, Your Honor? I lost my train of thought.
Well, I think following up on what you said, what should they have done? And I think I hear you saying they should have done more than they did, and by virtue of that, are you saying they waived it?
Well, I would argue that it is waived. I think it is a preservation issue, and we certainly did argue that as one of the arguments. I know that we had to make alternative arguments, and it's certainly possible that it is preserved for appeal or that it didn't need to be preserved for appeal. But I think just as a matter of basic fairness, the lower court should have had an opportunity before this appeal proceeded to review the issue, and she wasn't given that opportunity. And I think everybody concedes that. Unless there are any other questions from the court, I will rely on my brief. I would ask the court to affirm. Certainly, I think the order is sound. I think the only potential issues with the order deal with the property, but certainly this court can affirm as to the guardianship. They can affirm as to the court's finding that the powers of attorney should be suspended. This court can affirm as to the capacity issue, or we don't even have to reach the capacity issue. And as far as the property issues, if the court is not convinced that the appellant or the appellee had an interest, or the guardianship has an interest in these properties pre-guardianship and the trial court was correct, I think then the answer is that the Ponte Vedra property should go back as tenants by the entireties. But I think the condominium proceeds, I think those should remain the way they are, and I think the trial court got that right.
Condominium was not homestead, correct?
No, it was not.
Ponte Vedra was.
It was. That's correct.
Was refresh my recollection, was the Ponte Vedra homestead purchased during the course of the marriage?
Yes, it was, I believe. And so for those reasons, we ask the court for the relief requested, and thank you for your time.
Thank you, Mr. Croman. Mr. Hauser, you have a minute 54 for rebuttal.
Thank you. I better talk fast. I'm really tempted to get into the the incapacity issue, because the court got very close to where I wanted to go. I looked at his answer brief. He's got the statutory analysis right, okay? We didn't have standing to object to those committee reports to keep them from putting the ward into guardianship. We couldn't have appealed it. There's nothing to appeal. The only thing we can say is, hey, don't use those against us because we're about to lose stuff. And it turns out we did. So that's the problem with admitting the committee reports and using them against a third party. The legislature took away a third party's right to object to their use against a ward, and now wards can go into not bankruptcy, into guardianship solely on the basis of hearsay reports. That's true. The problem is taking away the rights of third parties and holding them to that conclusive determination which they had no standing to object to. That can't be. We have to read the code in consistent with due process. Any third party should be able to come in and say, look, I know he's in guardianship, but he's not really incapacitated, and my transaction X, Y, or Z is not infirm. I thought it was ironic that there is some doubt about whether the rehearing rule applies, and yet that rehearing rule is the rule that restates the general rule of appellate practice that it is not necessary to tell a judge that their own ruling is not supported by evidence. That's something I can raise on appeal without preservation. So the key issue here is the house. The house belongs to the wife at a very minimum at her entirety's property, but technically it belongs to her trust. But if we waived that issue, we waived it. It belongs to her by the entireties, and the injunction needs to be reversed. The exact same analysis applies to the condo proceeds. They belong in a joint trust. That's where they should have gone. They were never guardianship property. And so we asked the court to reverse and provide some relief to the ward's spouse.
Thank you,
very
Mr.
much.
Hauser. Thank you, Mr. Croman. Well presented on both sides. We are now in recess.
Good job.
Yeah, you too.